Hello, this is Dave at Car Titles. In this video, we're going to take a look at charge-offs, write-offs, repossessions, lien titles, and other related subjects to vehicles that have a lien or loan that's holding back the title or encumbering the title. One of the most common questions we get is about a vehicle that had a loan on it at one point. The loan had become non-performing or delinquent, and now the person wants to get a title. In many cases, the owner of the vehicle or maybe a purchaser has been in contact with the lien holder and they don't want the car back. And this is very common, and you might be wondering, like, why don't they want to come get the car? But there's a reason for it, and we'll talk about that as well, and methods of getting a title. First of all, what is a charge-off? A charge-off is a legal term that lenders use to describe a loan which is no longer what's called a performing loan. What does that mean? Well, when a bank or financial institution loans a person money, that loan is considered an asset on their books. Let's say, for example, you have $20,000 in your bank account. If somebody says, "What are your assets?" you could say, "I have $20,000. Well, banks can count the money they have in their bank. They can also count loans that they have lent out to people. So if a bank lends a person $20,000, they can say, "I have an asset of $20,000," because technically that's something of value to them. However, if that loan becomes non-performing, they can no longer call it an asset, and there's a reason why that's important. Banks and financial institutions, when they declare and state their value of their company for things like insurance or stock prices or financial reporting, have to add up all their assets and say, here's what our bank is worth. If they have a loan that's non-performing, they can no longer count that in the addition. So they have to make it a charge-off. What is a charge-off? Well, here's a great article for credit unions, but it applies to banks as well, and it gives you guidance on what to call a charge-off. And it tells you when the board deems the loan a loss, they must charge off the loan in compliance with disclosure requirements under rules and regulations. The policy should address loans representing a high probability of loss. Here's some examples. A non-performing loan more than 6 months past due. Delinquent loans in the hands of an attorney or collection agency. A skip where the credit union has had no contact for 90 days. Estimated loan loss in a excess of a certain value. So basically, if they haven't heard from the borrower in 6 months, gotten a payment, guess what? That's a charge-off. Many times we see banks and financial institutions use between 6 and 8 months. If they didn't get a payment, they have to make it a charge-off, and they have to report it to the regulatory agencies. So what happens when a loan is charged off? Well, the lender is a great article for Investopedia. What happens when a car loan is charged off? It means the lender no longer believes you will repay the loan, and they may sell your account to collection agencies or debt buyers. Technically, the borrower is still legally obligated to pay the loan, and it damages your credit. But the question is, what happens to the collateral? So if the loan is for an automobile and they sell the loan to a credit union or to a collection agency or debt buyer, who owns the car title? It's a gray area. There have been court cases where when a bank says it's a charge-off and they use it as a write-off on their taxes and they no longer can claim it as an asset, can they still claim the collateral? Sometimes they say yes, sometimes they say no. So what happens is many borrowers, or maybe even if you aren't the person who borrowed the money on a vehicle, maybe you bought the vehicle on Craigslist and you want to get that lien released, will submit a request to the lien holder for a lien release or a letter of non-interest. Many times the corporate counsel or the representative of that bank, or even just an administrative person, sees it and says, hey, this is a charge-off. We cannot continue to claim the title. That's not always the case. Sometimes they say, no, it's our title. We're going to hold the title, hold the lien until we get paid. You will be back in your video in just a few seconds. In the meantime, remember that actualhuman.com offers you live one-on-one private video consultation with an expert in this exact subject. We want to listen to your story. We want to hear your questions. We want to give you expert advisement of your options and tell you what we know about your particular situation. Now back to your video. It's up to the individual lien holder, especially based on what their interpretation of the law is. Now remember, we're not attorneys. We're not giving you legal advice. All we're saying is that if you have a vehicle that you need to get a title for that has a current lien, the only possible way to try to get that lien released is to submit a request to the lien holder. Now, it's important how you do this. You don't want to do it by phone. You don't want to do it by email. You don't want to do it electronically. You want to do it in writing. And what you do is you prepare a package, and this is how we do it. We prepare a package of documents, just like this, and it comes in a folder, and we send out a package to the lien holder. We send out a package to the vehicle owner. And the reason that we do this is because if you called up a lien holder and said, hey, give me a lien release, now somebody at that bank has to do work. They have to find the documents, fill them out, write them in, sign it, mail it. They don't want to do any work. But if you send that package to the lien holder, it may show up on some clerk's desk. They might type in the VIN number and says, oh, it's a charge off. I'll just sign it. And they mail it back to you. It's your only chance. There's no guarantee they're going to do it, but the reality is if you don't do that, you will never get a title because the DMV cannot give you a title if there's a lien showing. Now, here's the other side effect of this. If you send out that package to the lien holder and they don't respond, then what you can do is you can file a petition with the court to ask the court to override the lien and declare you to be the owner of the vehicle by court order. You can say, look, I tried to contact the lien holder. Here's the paperwork. I did it in writing. They never replied back. They never said they wanted the vehicle. So I'm asking the court now to override it and you sign the lien release. Can they do it? Yes. Can they say no? Sure, they could say no. Again, you're never going to know until you try. This is the process for removing a lien. This also, the same logic can be tried for things like real estate liens, mortgages, second mortgages, judgments on court cases. The most important thing is you have to make the attempt. Now, one thing to keep in mind is collection after charge off. This has to do with credit cards. However, it is a similar logic. If you are the borrower and you did not pay the loan on a vehicle, even if you get your lien release, that lender can still try to get the money. But how often does it happen? The Consumer Finance Protection Bureau found that an average of 8% of post-charge-off accounts were being collected internally. That's down from 22%, right? So fewer lenders are trying to collect internally. Now, they may send it to a third-party collection agency, but that's a whole different story. So there's a lot of conflicting data, a lot of conflicting advice. The most important thing is if you have a vehicle that has a lien recorded on the title, the most important first thing to do is officially request a lien release from the lien holder. Nothing can happen until that lien release is submitted to the DMV, and it has to be signed by either the lien holder or a judge or the court. And you do not, by any circumstance, want to contact a lien holder by phone, by email, by text message, on Facebook. The only way to do it is in writing, because if they have the papers in front of them, it's a real simple thing. They just have to sign it. If they have to do work like find the papers, look it up, print them out, that's just one more thing that'll keep it from happening. So loan charge-offs, repossessions, write-offs, title liens are all related. The only thing that you need to worry about is how do I get that lien off my title so I can then have a clear title to sell my car, drive my car, transfer it to somebody, maybe get insurance, maybe get paid from your insurance company so that you don't have that encumbrance holding you up. If you have more questions about lien releases and titles, you can click the link below. We also have a new website called carshortsale.com. If you have a vehicle that you owe more than it's worth and you want to try to resolve that, there's ways to pursue that as well. Thank you for watching another video at actualhuman.com and describe.tv. Remember, if you have questions or comments about our videos, put them in the link below. Also, remember that you have availability and access to live one-on-one question and answer consultation with a licensed expert in a number of fields: investigations, insurance, surety bonds, civil court mediation, even things like real estate records research, real estate brokers, real estate mortgage lenders. In addition, you're going to find that experts are available in business segments, business development, marketing, advertising, certified licensed experts. So if you do find this content valuable and you want to delve more deeply into a subject, you can't ask YouTube a question, right? But if you want to talk to somebody live, an actual human, use the link below. Thanks for watching.